Hi everyone, welcome to this session on private international law. Today we'll be looking at the choice of law rules in relation to individuals and corporations. Let's start with individuals. In almost all common law countries, the criteria employed to connect a person with the legal system in matters of personal status, succession, etc. is domicile. But what does domicile mean, and how do you determine a person's domicile in a given case? The root idea is the permanent home. This was how domicile was thought of as far back as 1858. However, domicile cannot be in practice simply be equated with home, still less with permanent home. The American Law Institute attempted a more formal definition of the term. This definition essentially does not attempt to describe the concept of domicile at all. Instead, it defines it as a legal concept that is relevant in the context of private international law as a connecting factor. Let us now understand the legal concepts of domicile of origin and domicile of choice. The law imposes on every person a domicile. This is attached to a person at birth by operation of law. This is called domicile of origin. A person's domicile of origin will generally be the domicile of the father if the person is born legitimate. If legitimate, it will be that of the mothers. If he is born after the death of his father, that person's domicile of origin will probably be that of the mother. This domicile that is attributed at birth will continue to operate until that person reaches majority, which is usually at 16 or 18 in different common law countries. In the interim period, that is until that person reaches majority, his or her domicile is essentially dependent on that of his or her parent, either the father or the mother, depending upon the circumstances of his birth. If the controlling parent's domicile changes, so too does the domicile of the dependent child. Now, once a person reaches the age of majority, he or she becomes capable of acquiring a domicile of choice. The basic principle is that such a new domicile can only be acquired by actual presence in a country with an intention to stay there permanently or at least indefinitely. Both these elements must be present. That is, the person must be physically present in the new country and on arrival or while he is there, must have formed an intention to remain there. It would be misleading to equate either or a combination of both of these requirements with a form of residence, even though domicile is sometimes described as permanent residence. An immigrant can probably acquire a domicile of choice as his ship or plane enters a country's territorial waters or airspace, provided the requisite intention can clearly be proved or have been there. At the same time, residence, however long and however stable, will not give rise to the acquisition of a domicile of choice unless the requisite intention is formed. For example, where a person works as an expatriate for many years in another country but never evinces an intention to shift his domicile there. Similarly, an intention, however firm and however likely to be implemented, will not by itself constitute the acquisition of a domicile of choice. For example, if an Indian domicile is keen on shifting to the UK but never actually makes any practical move to physically relocate, his domicile remains in India, even though he has clear intention to shift his domicile to the UK. In short, neither residence, however long, nor intention, however strong, alone suffice. Both have to be present. Once acquired, the new domicile will continue until either a second or subsequent domicile of choice is acquired in the same way as the former domicile of choice was acquired, or that former domicile of choice is abandoned. It cannot, however, be abandoned either by simply moving elsewhere or by simply making a firm decision to do so and to do so permanently. It can be abandoned only if the person actually departs and then, while still away, decides to never return. In these circumstances, the domicile of choice will be lost. If no new domicile of choice is then immediately acquired, the domicile of origin will revive. The doctrine of the revival of the domicile of origin serves to preserve the common law rule that there should never be a vacuum in a person's domicile, but the doctrine can lead to bizarre results sometimes. Suppose, for example, a person with an English domicile of origin acquires a domicile of choice in France and lives there for many years, during which time he never returns to England. Late in life, he decides to emigrate to Australia. En route from France to Australia, he is killed in an air crash. An English court would in these circumstances hold that he has died domiciled in England, as he's lost his French domicile but not yet acquired an Australian domicile. The problem with this type of revival is that it goes against the notion that a domicile is a person's home. Nevertheless, the doctrine still forms part of common law, including India. That concludes a high-level review of the common law rules on domicile. India by and large applies these common law rules, although the impact of personal religious laws reduces the scope of application of these rules in the context of matrimonial and other type of personal disputes. Next, we'll briefly go over the laws that govern the status of companies. Like individuals, companies too have a domicile and residence. The domicile of companies is considered to be their place of incorporation. Domicile is used to determine the applicable law in cases concerning the status and internal management of the company, its existence and dissolution. On the other hand, a company's residence is where its central control and management is situated. Residence is generally important only for tax purposes. While we won't get into too much detail here, remember that insolvency is slightly unique. Insolvency of a company is generally always determined on the basis of lex fori. That concludes our discussion on the applicable laws for individuals and corporations. Thank you for watching.